Dear ladies and gentlemen, it's a great joy to meet you in person and an honor to participate in this research and also on this conference. The topic of sustainable finance is at an early stage in Hungary. The whole sustainable finance and environmental and social governance concept is still in its infancy. My colleague and I were in a difficult situation. There is no relevant Hungarian legal literature. The current literature deals only with the EU regulation. We could use only the recommendations and executive circulars as internal regulations of Hungarian National Bank and some economic studies. We contacted several Hungarian law firms, but they also did not have any relevant information. The Hungarian implementation is almost a literal translation of the EU directive, and the detailed rules are sporadic and systemless. So our task was for us a real challenge and required both persistence and dedication. And beside this, we are private lawyers, and you can see our approach reflects it. We divided our Hungarian national report into two parts. First, I speak about the regulation background, the relation between Budapest Stock Exchange corporate governance recommendations and CSR, a starting point, and furthermore, the identification of shareholders, the shareholders' right for the confirmation of voting, and to vote on the remuneration policy and to approve the related party transactions from the aspect of Hungarian Civil Code and Hungarian Public Companies Limited by shares. Afterwards, my colleague János Dul will speak about the target market determination in Hungary and the role of Hungarian National Bank in sustainable finance, for example, in connection with the issues of green bonds. The Hungarian regulation of the encouragement of long-term shareholder engagement is fragmented and not connected with each other. So I could not make a so nice slide as made Professor Ekenga because our regulation doesn't have any logical structure. The Implementation Act is the Act 67 of 2019 on the encouragement of long-term shareholder engagement. This modified Hungarian Civil Code, the Act on Capital Market, and the Act on Investment Enterprises and Commodity Exchange Service Providers. In response to Professor Ekenga's questions, we still had to use yet the Act on Credit Institution and Financial Enterprise, the Act on Forms of Collective Investment and their managers, the Act on Bankruptcy and Liquidation Proceedings, the Act on Employers' Pensions and their institutions, one decree of Ministry of National Economy on the product approval process, and several recommendations of the supervisory authority, the Hungarian National Bank. To establish the relation among these legislations and provisions is difficult. Only the Hungarian Civil Code is a private law norm with default and mandatory rules. The others are public law norms and special regulations only with mandatory provisions. It is not easy to decide which law is applicable and the regulations are with other personal scope. A study you can see on the ground of the slide in the frame of studies in banking and capital markets law conducted by the European Banking Institute analyzes the responsible corporate governance codes or recommendations of the EU member states, including the Budapest Stock Exchange corporate governance recommendations in terms of CSR implications as corporate governance, sustainable finance, environmental and social governance. Regarding the examined sustainability factors, the Hungarian corporate governance recommendations were not well presented. The purpose of the corporate governance recommendations is not linked to CSR. These recommendations don't contain the definition of corporate governance in any interpretation. These don't cover sustainability requirements. The stakeholders are only mentioned, but without definition. The CSR committee and the report on sustainability compensation and the informants of non-financial aspects such as ECG and its publication were omitted. But this did include the validation of employee interests and the pursuit of gender balance, as well as ethical clauses without a code of ethics. The regulation on the identification of shareholders by the company, in order to facilitate the exercise of shareholder rights and direct communication between the company and the shareholder, has remained unchanged in the Civil Code. The rules of shareholder quality certification and ownership matching have not changed. The Implementing Act establishes the company's right to identify its shareholders with reference to the European Commission's implementing regulation on the details, and shortly amended the Act on Investment Enterprises and Commodity Exchange Service Providers and the Act on Capital Market. These modifications are the following: the provision of data by the Securities Account Manager to the public company limited by shares in order to provide shareholder identification to the public company limited by shares does not constitute a breach of securities secrecy. The ownership matching shall be carried out without prejudice to the shareholder identification requirements, provided for in a separate legal act for a public company limited by shares. The Budapest Stock Exchange corporate governance recommendations don't contain a recommendation regarding the identification of shareholders, nor is there any reference to a new type of shareholders identification on the websites of the examined Hungarian listed companies. There is no trace of any information for their members. I had examined 5 big Hungarian companies. MOL is the greatest gas and oil company in Hungary. OTP is the greatest financial institute. Richter Gedeon is a medicines producer and distributor. Tzfak Unicum produces and distributes a special alcoholic drink. Its name is Unicum. And Hungarian Telecom is a telecommunication company. The implementing regulation of the European Commission applies a 4-step solution to the assurance and verification of the exercise of shareholder rights: identification of the shareholder, confirmation of the right to exercise the shareholders' rights at the general meeting, notification of participation in the general meeting, and formalizing the confirmation of the casting, recording, and counting of the vote. The Implementing Act amended the Civil Code only with regard to the probability of the vote, but not in full and with respect to the same voting moment. The first amending rule is in connection with the participation in the general meeting. At the request of a shareholder, the board of directors shall confirm to the shareholder or a person designated by him that the shareholder's vote has been duly recorded and counted at the general meeting. The second one, regarding the conduct of a conference general meeting, if a vote is taken at the conference general meeting by electronic means, it shall be ensured that the shareholder voting by electronic means receives an electronic confirmation of the casting of the vote. You can see that the first rule regulates only the next steps after the casting of the vote, and the last one only the casting. And the first one is not mandatory, but the second one is a mandatory rule, and automatically at the conference general meeting that the casting of the vote, the board of directors can confirm. But at the first one, you can see the beginning of the sentence at the request of a shareholder. And in my opinion, the shareholders in our public companies by limited by shares don't know about this right. And the board of directors don't have to confirm the recording and counting of the vote only after if the shareholders ask it. In the implementing act penalizes the failure to confirm the vote, treated as a corporate obligation. In such a case, the shareholder may initiate a judicial review of the resolution passed by the general meeting, even if he or she has consented to the resolution. We do not consider this legislation to be an adequate solution because the decision is not illegal here. It does not infringe any law or the memorandum of association. Here, the participation in the decision making in the voting and the vote were not confirmed. In this case, it is not a question of the shareholder not being able to exercise his or her voting rights, but of the fact that the public company limited by shares does not prove that the voting process per shareholder, casting, recording, counting, and confirming of the vote has taken place in accordance with legal regulations. In view of this, and taking into account who is entitled to sue in judicial review of decisions, a person who has not consented to the adoption of a decision by a vote, and without breaking this clause, we consider it much more appropriate to initiate the judicial oversight proceedings of the Court of Registration. Judicial oversight proceedings are appropriate if the firm does not comply with the legal provisions concerning its organization and operation. The Budapest Stock Exchange corporate governance recommendations don't contain any express recommendation or reference to the certificates, nor does the website of the studied Hungarian listed companies. The Hungarian implementing legislation applies a consultative solution to the remuneration policy and reporting of directors. Shareholders only have the opportunity to express their views, and in the event of a resolution of the general meeting rejecting the remuneration policy, but the payment must be made to the company's directors on the ground of rejected remuneration policy. The consultative powers of the general meeting of public companies limited by shares are strange in company law with German roots. First, this implementing act establishes this new type competence of general meeting in Hungarian company law. In our view, with this regulation, the shareholders and the general meeting were given likelihood authority because of the Hungarian Civil Code regulates that in the event of a significant change in the remuneration policy, but at least every 4 years, it shall be placed on the agenda of the general meeting. The new competence of the supreme body of public company limited by shares or triggers a continuous dialogue and cooperation between the decision-making and the operating bodies in order for the company to operate for legitimate and public interest purposes, or results in the management becoming self-sufficient and the opinion of the general meeting on the remuneration policy not being validated. Budapest Stock Exchange corporate governance recommendations show a passive attitude, a range to wait. Reference to that, some practical experiences will be summarized after a few years later. The websites of the examined Hungarian listed companies show a somewhat mixed picture. MOL published its detailed remuneration policy. OTP, Szwakunikum, and Hungarian Telecom including less detailed remuneration guidelines on their websites. Richter Gedeon's remuneration policy is not published on the website. It can only be concluded that there is from the 2022 general meeting proposal. And these public companies limited by shares did not make easier to find their remuneration reports. They can be accessed with a few searches and many clicks on their websites at the end of the general meeting submissions. The Implementing Act, as a general rule, gives the company's management the power to approve transactions with related parties, allowing a derogation from the company's articles of associations to refer matters to the general meeting or supervisory board, at the last one, provided that the company has a dualistic organizational model. In line with the preamble to EU directive, we find the interests of companies and shareholders to be better served and more appropriate in terms of legal certainty for the supreme body as general meeting or for internal controlling body as supervisory board to have the power to validate or invalidate the transactions with related parties. On the other hand, we consider correct the provision that the person directly involved in the related party transaction, including the person concerned is the related party, not to be involved in the approval decision. Overall, we see that the measures to encourage long-term shareholder engagement will be embodied in the declarations for the time being in Hungary that will not be easily accessible. There is still work to be done for Hungarian public companies limited by shares, and also in the light of the joint proposal for a directive of the European Parliament and of the Council on corporate sustainability due diligence.
Dear ladies and gentlemen, dear professors, dear colleagues, thank you very much for this great honor to participate in this research. As Professor Papp mentioned, my presentation will cover some practical issues like target market determination through some legal acts and the recommendation of Hungarian National Bank, HNB. I will also present certain topics in connection with the role of the HNB in sustainable finance. Regarding the target market determination, the potential target market cannot be identified solely based on quantitative criteria. The designer must also take due account of qualitative aspects. In particular, for mass market services, process automation based on formulae or algorithm-based methods that process quantitative criteria for products and customers may be relevant. Such quantitative data is usually generated by some kind of scoring system, for example, using product characteristics such as volatility of financial instruments, issue ratings, etc., or by converting factual data into a numerical system. The Hungarian National Bank expects that the enterprise should not rely exclusively on quantitative criteria when identifying the target market, but should also balance them with qualitative criteria to a sufficient extent. The Hungarian National Bank also expects that the designers to use the list of categories mentioned below as a basis for identifying the potential target market for the product, using each of the categories in the assessment of the target market. The identification of a potential target market by the developer, categories to be examined. First, the type of customers that make up the target group of the product. Second, knowledge and experience. The company provides information to potential customers on how to understand the product. They must have knowledge of the various elements, such as the product type, product characteristics, and or related thematic areas. Third, financial situation, with particular emphasis on loss-bearing capacity. The company specifies the percentage of loss-making capacity that potential customers must have. For example, from a small loss or to a total loss. Whether there is a payment obligation in excess of the amount invested. For example, the provision of additional cover or the maximum proportion of assets that can be invested. Fourth, appropriateness of risk tolerance and product risk return profile for the target market. The company specifies the general attitude of the target group to the investment risk. It is recommended to categorize and clearly characterize the basic attitude towards risk, such as risk-seeking, speculative, balanced, conservative. Fifth, customer goals and needs. The company specifies the investment goals and objectives of the customers of the product group, designed to meet the needs of the client, including the broader financial goals of potential clients and the overall strategy they are pursuing in relation to the investment. For example, a product can be designed to meet the needs of a particular age group, tax efficiency, depending on the tax jurisdiction of the client, or may be designed to achieve specific investment objectives such as currency protection, green investment, or ethical investment. The identification of a potential target market must be carried out in an appropriate and proportionate manner, taking into account of the nature of the product. This means that when identifying the target market, a product characteristics, including its complexity, cost, fee structure, risk, reward profile or liquidity, and innovative nature. The Hungarian National Bank expects the distributor to pay particular attention to the investment services through which it offers products to the target market. In this regard, due consideration should be given to the nature of the products, in particular those products that are characterized by greater complexity or risk, or other similar characteristics, such as lack of liquidity or innovation. This is in line with Recital 18 of the MiFID II directive. The investment enterprise shall regularly review the financial instruments it has developed, taking into account any event that may have a material effect on the identified target market. The investment enterprise shall also periodically review and update its product approval processes to ensure they remain sound and fit for purpose and take appropriate action as necessary. The investment enterprise shall regularly review the financial instruments it offers or recommends and the services it provides, taking into account any event that may have a material effect on the identified target market. The review shall assess at least the consistency of the product or service with the needs, characteristics and objectives of the identified target market, and the adequacy of the planned marketing strategy. The management body of the investment enterprise shall monitor the product approval process of the investment enterprise in order to determine the range of investment products and services offered to the relevant target markets. This compliance reports to the management body shall include information on the products and services offered or recommended by the investment enterprise. The investment enterprise shall make the compliance reports available to the Hungarian National Bank upon request. The Hungarian National Bank expects regular reviews to take place at least annually. In connection with the role of the Hungarian National Bank in sustainable finance, it introduced its Green Capital Requirement Reduction Program from 2020, which enables the bank to improve the energy efficiency of its sustainability considerations have been taken into account in one of the mandates of the Hungarian National Bank. Based on the amendment of the relevant legal acts, the Hungarian National Bank can use the instruments at its disposal to support the government's economic and environmental sustainability policy. The renewal of the resource base of the green renewal policy is thus can be implemented in a coherent manner. The Hungarian National Bank is convinced that it is essential for the operation of the listed and long-term successful companies, beside the responsible corporate governance by management, the active shareholder involvement engagement in monitoring and controlling the operation of the company. Today, beside the proactive supervisory action, it has therefore become necessary to strengthen corporate ownership control. Therefore, the Hungarian National Bank encourages shareholders to continue to the best of their ability to monitor issuers' disclosures, exercise their ownership rights, participate at general meetings, ask questions, find out and exercise their voting rights. The aim of the Hungarian National Bank is to facilitate the transition of domestic credit institutions to sustainable operations and to prepare them opportunity in terms of climate change and environmental risks, relevant legislative changes. In this respect, it was created on this website, can be translated as greenfinance.hu. The knowledge base section provides practical help with examples, good practices and usable data, and the collection of methodological resources. The Hungarian National Bank considers it important to highlight the potential business of these processes. They also provide opportunities for credit institutions, which may include new or even innovative developments of financing solutions. For example, for the financing of local energy communities or the development of dedicated green banking products, such as improving energy efficiency, financing and a loan related to sustainability or ESG aspects. ESG-linked loan or sustainability-linked loan. The Hungarian National Bank considers it a good practice to have a credit institution informs its customers about the environmental sustainability of their products and services, climate change, and environmental sustainable contribution to the objectives. The third topic is on the issuance of bonds and on the so-called growth bond program. The first issue of corporate green bonds took place in the summer of 2020 within the framework of Hungarian National Bank's growth bond program. With this issue, with a nominal value of Hungarian forint 30 billion, circa 85 million euro, the development of the corporate green bond market in Hungary started. The issuance of green corporate bonds in Hungary has so far been a real estate developer sector, which is a key area for reducing carbon dioxide emissions and mitigating climate risk. In addition, the move by banks to green clientelism is also encouraged by the Hungarian National Bank's Green Investment Capital Relief in Hungary. The taxonomy regulation is an also important part of domestic financial market incentives, such as the green recommendation issued by the Hungarian National Bank or the Budapest Stock Exchange ESG reporting guideline. The Hungarian National Bank has played a significant role in launching and ramping up green bonds in Hungary through the growth bond program, with the first issuance taking place in the summer of 2020. Issuing companies had been able to raise a total of about 850 million euro. However, the Hungarian National Bank closed the program as part of its tightening cycle in December 2021, raising the question of whether there will be any more corporate green bond issuance. The other question is, what will happen to the bonds already issued, or more precisely, to the part of them that the central bank did not buy? For the time being, there is in practice no secondary market, as the investors are largely banks, which do not buy and sell the paper based on different economic analysis. The Hungarian National Bank stopped its program. However, it released an issuance guide in January 2022. In my opinion, the Hungarian society nowadays is not ready for the topic of sustainable finance. Bigger commitment is necessary in order to be able to think more sustainable. However, certain trends give me hope that we can be successful in the near future. Thank you very much for your attention.